There have been many points of view on whether or not to take the dispute with Guatemala to the International Court of Justice. For those from the government, and more specifically from the Ministry of Foreign Affairs and the referendum unit, the messaging has been consistent. That is, that Belize has a robust and seemingly unbeatable case to take before the courts. In his interview in The Hague, we asked Ambassador Vernon to outline those strengths.
Guatemala is the one that is claiming us. So they will have some positions that they will take to the court if we get there. And they will have to prove several things that we on the Belize side believe that they can never prove. But the three major areas that Belize has in terms of our arguments are that the British and then Belize have occupied this country from the Rio Hondo to the Sword Stone since the 1820s, and we can prove it. That most importantly, and this is where perhaps the court will focus on more than anything else, perhaps only, the 1859 treaty defined the borders of Belize very, very clearly. It's a treaty that is recognized, that stands, and that cannot be disregarded. And we will also use the argument, I believe, once we get to the court, of becoming an independent nation in 1981 with the support of 139 countries of the world, with territorial integrity, with sovereignty, and that when we became independent at that time, it was done so with the assumption that the territory we inherited from the UK is the one we have now. Clearly, the United Nations resolution is not a legally binding document, and the borders of Belize were not demarcated by that resolution, but we can use that argument as one of the key arguments as to why the country that we now call Belize is ours. But it will hinge on the 1859 treaty more than anything else.
But just how valid would this 1859 treaty be in court? In truth, no one can really say until and if the case is argued in the I.C.J. Nonetheless, when speaking with the international law experts at Leiden University, we asked them how the principles of international law would apply to such a treaty.
Can we get your insight on the 1859 treaty? This, we are told, is one of the main strengths of the Belize case, because by our definition, it is a boundary treaty. However, there is non-compliance where it comes to building the cart road with access to the sea, which many believe may be a reason for Guatemala to discount or to push that the treaty is invalid.
The question is whether one is conditional upon the other, right? Whether you say we determine the boundary as such only if and to the extent that we build the road. I don't know how it's drafted. That's not the case. There is one principle that is often applied, of course, in international law, which is in Latin the exceptio non adimpleti contractus, which is the rule that you have in contract law as well, is if one party fails to meet its obligations, the other one can refuse to comply with its obligations. That's an important principle of contract law that's valid for treaties also. So I wouldn't say, based on what I have read, the treaty is void, right? That is, the treaty still is there. But the question will be whether the non-performance by the then sovereign, which is Britain, would justify that the other state does not have to meet its obligations. But the rules are basically you have to assess whether the non-performance by one state is sufficient enough to justify the other state not performing its part of the deal. Right? And the gravity here depends on what is the type of obligation, and it also depends, if I remember well from what I read, is that the idea that the boundary no longer needs to be respected by Guatemala because the road was not constructed is a claim that was made many years after the treaty.
Yeah.
So this is also an element to be taken into account, is to what extent was it then really a condition, right? I don't know, but this is a balancing exercise that the court will make. So it's international law, right? So you have a variety of rules that are relatively clear. How they apply in a concrete situation is always an exercise of But in this case, the question will be, is it grave enough? Is it conditional? And what is the effect of the fact that the claim was made roughly until not made until 1930, 1940 or something? What does it say? We have, of course, certain rules that relate to acquiescence or estoppel, which basically say that you have a certain position that you take. You cannot constantly contradict your position in a subsequent case if you have taken a firm position before. Now, in this case, it's a bit tricky because the claim has nonetheless been made since 1940, with 2018. So it's not as if it's a new claim from 6 months ago, right? So there was nothing done between 1859 and 1940, but still, since 1940 until 2018, there was a claim. So, yeah, again, there's a long period between the treaty and the claim, but there's also a long period since the claim was made.
What about those who insist the claim by Guatemala should be settled by the British, since they were the ones who signed the treaty? That question was also put to the legal experts.
The dispute and the boundaries is between you as a sovereign state and then Guatemala as a sovereign state. So the only question that will come into play is whether the treaty signed between the former colonizing powers was valid.
In case of decolonization and succession, the principle that applies, again, sorry, it's another Latin phrase, is uti possidetis, that is the lawful possession of the colony passes on to the new state, and that's the rule that is recognized to apply. So in this case, it would be, it's now the territory of Belize.
So you inherit the boundaries, internal administrative or external boundaries of the former, as a former colony.
Which means we also inherit the responsibility of finding that solution, whatever that may be, come April 10, 2019. Reporting from The Hague for News 5, I am Marleni Cuellar.